stop and frisk, you don't see it or hear it in the news as much because the police now knows that we're out there and we're monitoring. Now, discovery for justice, right? We're trying to monitor that now in the court. And basically, what's going on is everyone here has the perception that when someone is accused of a crime, that there's a level playing field. There is not a level playing field. And what we mean by that is evidence. Evidence that is brought against the accused. The district attorney gets because the police gather the evidence. And they hand it over to the district attorney. And what this law CPL 240 does, it allows the attorney, the DA, to withhold evidence, not giving it to the defense, until an hour or two before trial starts. Now people will say, oh, an hour or two. But let me tell you what happens. You have an accused who is sitting in jail for a year, year and a half, 2 years. And while they're sitting in jail, they're asking their attorney from the day they were arrested, from the first day they came into court, hey, what's the evidence against me? And their attorney is saying, I don't know. I can't get it. Because the district attorney won't turn it over. And it's not because they won't. They can turn it over if they want to. They can. But you got to understand, when you're holding all the marbles and you're going against an opponent, you want to win. Right? But we also want to win in the interest of justice, not convictions. But when you, at times, people tend to move up the ladder when you come to the DAs with convictions. Convictions, like I said. They also want to do it in the interest of justice, but you can't tell me when somebody is arrested and they're sitting in jail for a year, year and a half, and their attorney wants to see the evidence, that you're going to withhold that. And then to add insult to injury, during that time, the district attorney will get in touch with the defense and say, hey, you know what, your client's been sitting in jail for like a year and a half. I'm going to make them an offer, which is plea bargains. Because 97% of court cases are plea bargains. 97%. You ask why? Because if everybody was to take their cases to trial, the system, you think, is backed up now, right? It would be backed up and we would be long gone from here. You know, because there's not enough judges, right? However, when the district attorney decides to make a plea offer, the defense is still not given the evidence to go to his client and say, listen, the DA is going to make an offer in this case. You're facing, I'm just going to throw, you're facing 15 to 25. However, they're going to bring it down to 5 to 10. All right, now if the defendant wants to take it, he says, okay, well, let me see the evidence. We don't get to see the evidence. We don't get, you get to make this decision blindly. Blindly, right? So now that defendant has a decision to make. Now you got to remember, they've been sitting in jail already for a year, year and a half. And they've been told why they're arrested, but they haven't been shown or given any of the evidence because their attorney can't get it. So you can imagine what that person is going through and what their family is going through, because they're speaking, they're on the outside and they're calling that lawyer who has other cases, and that other lawyer can't really only but so much entertain them. So when this plea bargain is offered, right, 9 times out of 10, it's taken, right? And let me tell you 2 things that can happen behind it, right? Once a plea is taken, right, the defense counsel still never sees the evidence, right? Now, the reason why I say that is because the evidence could have been so shoddy that a defense counsel said, hey, he would have told us, we're going to fight this because you know what? We can win, right? However, what's even worse is that the person can sit in jail for a year and a half, 2 years, right? And then the district attorney, the case is called, and that person comes into court, and the district attorney can say, you know what, Your Honor? We have decided that we're not even going to pursue with this case. We're going to drop all charges. And then that person gets to walk out of jail. But you know what? They stayed in jail for 2 years. All right? They stayed in jail for 2 years, not knowing what evidence, if the district attorney had any evidence, right? And you know what? This person is going to be forever scarred. Forever scarred. Because even though the district attorney decided to drop these charges, you don't think that that blemish on that person's record is going to follow them? So you mess up their family life, you can mess up their career, you mess up their life in general. In general. We need to change this law. Now the reason why it came about during the Rockefeller drug laws. Because in the 60s and the 70s, when crime was running rampant, right, the governor, they wanted to put a stranglehold on crime. So the governor gave the state of New York district attorney so much leverage to say, hey, because before that, everything was even. Where the district attorney would get evidence and they would hand it over to the defense so that we could have a level playing field in court. Once that was taken away, the convictions rates have skyrocketed. Because you know what? Because a plea bargain is a conviction. You see? And they started going up. So when one person holds all the marbles, right? And they don't want to give up those marbles, you know, because why? Because of their convictions, they can get promoted. They can get promoted. And this also is a numbers game. This also happens with the police department. All right? Everything happens with numbers. You got to produce numbers. You know, it even happens in the judges' chambers at times. It's all about numbers. But thank God, with Judge Tapia, right? Like Kenny had said, Judge Tapia, there's two types of judges, right? You got an appointed judge, then you got an elected judge, right? And I was fortunate enough to work on his campaign right from day one, where we got him elected, right, to his judgmentship. And second of all, I carried petitions and worked with him to get him elected as a Supreme Court justice. Now, what that allows him to do is, right, he's beholden to justice and to the people. Now, there are elected judges. I mean, there are appointed judges. These appointed judges have to, not taking too much away from them, however, they are appointed. They can be removed. So usually, they are in favor of the people who appointed them and whatever their views are. I think all judges should be elected. Or every last single one of them. I also, to throw out there, I also think that the police commissioner, when I ran for office, I thought the police commissioner should be in an elected position also, being beholden to the people and not to the mayor. Because at any time that a police commissioner goes against the mayor, they can be fired. We saw that with Giuliani and Bratton before. You know? So, with this discovery for justice, what we are trying to do is we're trying to make the system fair and even. We want, the minute that the district attorney gets evidence against someone that's been arrested and accused of a crime, we want them to turn that evidence over to the defense. So that what it will do, it will give that defense counsel enough time, right, to come and properly prepare for the case. Because when that defendant is sitting in jail and the case finally comes, 2 hours, really 1 hour, before the first witness takes the stand, 1 hour. So if the proceedings is going to start at 9:30, by 8:30, this is the DA. This is the DA to the defense counsel. Here is my evidence. And the defense counsel is saying 1 hour, I got to try this case within 1 hour. I can't look at all of this right now. So most of the time they say to the judge, I just was handed the discovery an hour ago. Can I have a week or two to prepare? You know what the judge says? No, I'll give you 2 days. You know? And you know what? Of course, the person who's been sitting in jail doesn't want 2 weeks more either. Especially when they know that they're innocent. Especially. And like I said earlier, right? Like Judge Tapia said, we are not here to bash the district attorney's office. But our good friend Dennis Slattery, if you read the paper, the Daily News, just Sunday, wrote an article. In this article, there was a young man, Hispanic man, who sat in jail for 8 months at Rikers Island on a charge, right? That the witness later had recanted her story. All right, it was a rape case. However, she later on said that she wouldn't testify, but that the rape did occur. However, before she had given a statement to a police sergeant, a detective, saying that it was consensual. This information was given to the district attorney. The district attorney, her excuse to the judge, which the judge wasn't taking it, was that so many people handled the case that statement that eventually freed that young man was buried in her paperwork. Was buried in her... You can't tell, as a retired detective, I am here to tell you that when we locked people up and we gathered evidence, because I've handled cases from robbery to murder to kidnapping, when we get the evidence, we voucher the evidence the same day we make the arrest, or as we're gathering it, we voucher it. It is then stored. When before the trial even starts, if the district attorney wants to see it, we go retrieve it, we give it to them, we give them statements. So they know everything. They know every single thing about that case. For this DA to say it got buried in the case folder, however, one of her supervisors brought it up to the judge because they knew that the paperwork was there. And the minute he brought it up to the judge called the DA in there, and the judge gave the DA a piece of his mind, letting her know that she has tarnished the DA's office, which he at one time was a DA, right? And that she is never, ever, ever, ever to step foot and try a case in his courtroom, because he didn't have the power. He did not have the power to disbar her. Right, but he said, and all judges hold that, once they find that any counsel is not being truthful, they have the right to say, you will never ever try a case before me again. Now, that young lady is still with the Bronx District Attorney's Office. Now, let me just tell you something.
What's her name?
Morally, maybe we would say it was wrong. But according to the law, she did nothing wrong, because she could have withheld it, which is what she did. That's why we need to repeal this 240. And we need to bring in 245, which says that when a district attorney gets any evidence from the police concerning someone arrested, turn it over to the defense counsel right away. So that if you do forget, DA, well, you know what? That defense counsel is not going to forget. Because you know what? That defense counsel wants to get rid of that case as soon as possible. And we don't want innocent people put in jail for no reason, especially when there's evidence right then and there that proof that they didn't do the crime that they did. And make no mistake that once a person is arrested, they are, like I said, forever scarred. When they go for a job, okay, the employer can't discriminate against them because of a record. But you know those questions that come, have you ever been arrested? Have you ever been convicted? Right? And then they go and they pay investigators to see your record because they're about to hire you. And when they see what you've been charged with, they will say to you and look you dead in your eye and say to you, we'll call you. And you know that call is never, ever, ever going to come. And then we wonder why the employment rate is so high. Because even though I don't think anybody in this room, including myself, and I'm a leader in training in my church, right? I don't think anybody in here is a saint, all right, and never did anything wrong. And never did anything wrong, right? We make mistakes, but we don't want to be held forever because of one mistake. And especially if that mistake is on somebody else's end and not a mistake of your own. So we need your help. Please don't take this anger. This is passion. This is passion. Because this is what I do. All right, I've been retired since 2004, and I continue to fight the police department. Only on the injustice that is inflicted on anyone, especially poor people. Because most of the time, rich people don't go through what poor people go through. You know, I'm not knocking them, but they don't go through. You know, there wasn't an uproar with the stop and frisk. There wasn't an uproar south of 96th Street. All right? There wasn't an uproar. We knew where the uproar came from. We need your help. Judge Tapia said, this is Senator Klein and Ruth Hassel Thompson. What the judge didn't mention was Senator Ruth Hassel Thompson has been behind this also, all the way, all the way. And we need this to change now. We're not saying that everybody in jail deserves to be out. We're not saying that. But as a detective, I am here to tell you that there are some people. We see just a few days ago, a guy was in jail for 24 years.
Yes.
Right. There are some people that are in jail that don't belong in jail. And most of them are in there because of this CPL 240. You know, it's not right. It drains families of money or resources unnecessarily. And let me tell you something else. The court system. Two essential things that the court system could alleviate is time and money. You know how much money is being wasted because someone is sitting in jail for something they didn't do? And this money can come back into our communities. We can open up more senior citizen centers. We can open up youth centers. You know what I'm saying? To get our youth off the street so they don't have to encounter the police. Put them in a safe environment where they can work on whatever major expertise. We can limit the contact between our youth and the police. Resources that we need desperately.
Absolutely.
And one other thing, out of all of these states, there's some states that practice open discovery. Right across the bridge, we have New Jersey. Right across our bridge. And let me tell you something. Bad people are being convicted and innocent people are being free. All right? So they're not giving up the whole house. You know? And of one state, as of January this year, one state has also now come into existence with open discovery, which is Texas. And I'm going to let Judge Tapia
that's big for Texas.
speak to you about that.